I am continuing where I left off with the last negligence video, and I'm going to sort of scroll through, and you may read the background or pause it if you want. But basically what I'm doing is just to keep you up to speed if you're new to this channel, this is a variety channel, and it's sort of morphed into different things, so it covers a lot of different things, but basically what I'm doing here is I'm going through these Emerson bar review videos, which are archived and they're donated to the public. And I'm working on the torts ones, and I'm reviewing them, and I'm trying to supplement them. And one of the reasons is that they're kind of hard to follow because they don't have the workbooks. They don't identify all of the cases that they're referencing. And so I actually am searching the web for the sites and different places. I actually found one of the essays after the last videos that he was talking about, but the other two I still haven't found. So I couldn't even find the model answer, but he discusses it and he tells, what should be covered. But I have a lot of law books and a lot of things to cross-reference, so what I did is I put in my cross-references in here, and I'm going to move into the subject matter because I know a lot of people might be just wanting to get to the nitty-gritty. You can speed this up or slow it down. If anybody wants to put timestamps in, that would be great. Basically, I watched the 3rd-hour video, and I condensed the 2 other hours into like maybe an hour video. And I added in other things I thought might be helpful to cross-reference and understand better. So let's just quickly go over negligence for a minute. What are the elements of a negligence torts case? Their duty, breach, causation, and in the state of California they use actual and proximate cause, which I'm about to discuss much more in depth, and then the harm and the damages. And also you want to include defenses, so I'm going to talk about that later, but this is going to be primarily focusing in on causation, and I found a couple of relevant cases to help discuss that. So you can go look at the other videos for the reasonable person, the duty, and all that. Okay, I actually did add to the outlines and the notes on this, and I might do another summary afterwards. It just depends on time and everything. Okay, so we're going to scroll down to the causation section. And I did point out that you might have an opinion about what the law ought to be, but the law is not always what you think it should be. It's what has been decided in the past, and not all the technology and the information we have now has caught up with the actual precedent or the practices. So it may take 30 or more years for the courts to catch up with reality. I do say that because basically, it takes a while for things to catch up, and it's just traditions and different things like that. So I was pointing out my understanding through psychology of children's developmentally appropriate activity, but they're trying to do a legal, they're trying to hold somebody responsible, and like I said in the other video, the parents are often held responsible. So we looked at some cases for in the past as well, and discussed all of that. So I'm just going to kind of slowly scroll over to the Oh, I did change the background color a little bit so that it can help differentiate. Some stuff might be popping out at you more. So I did hour 1 and hour 2, and I cited the important cases that you ought to know if you're going to be studying for the bar in California. Now, let's go to day 1, hour 3. Okay, so Emerson's going to be using 3 cases of causation and liability, and he's focusing on the essay portion, a multi-state of the California bar, and he names Transco Case, which is about a train and an obese driver of the train, and then some sort of electrical pole, an electric company, and then a plumber case. Okay, so I found the Transco case, and if you look in the drop-down box, you can find it. I did not find the model answer, but I did find out it was from 1998, and it is possible I could search more. Somebody else could, and if you can find it, just post it here. These other cases. So the Transco case that he refers to talks about what theories can Paul recover damages and what defenses can he reasonably raise. Now, when he talks about causation, Emerson, he discusses the different proximate cause, actual cause, and direct and indirect, and the substantial factor test. So it begins here, and at about 30 minutes is when it starts getting into the damages and other stuff. So here's what I want to say. There's a couple of scenarios that he talks about with causation, and this is when there are multiple tort feasors that are concurrent. He didn't really get into it that much, but I looked it up. And another issue is the Eggshell plaintiff that you should know about. And this was an English case from 1901. I put it in here. He does not talk about it, but it's important that you understand that you take the plaintiff as you find them. And it's going to be sort of case by case. There's sometimes going to be splits in opinions. So the Summers versus Tice case, I'm going to just quickly tell you in a nutshell. There were 3 hunters out hunting quail, and 2 of them were together, and they heard something, and they went and shot at what they heard, and it was another hunter, and they shot him in the eye. And so they both shot at the same time, and they didn't know who to blame. So this is a seminal case because the burden of proof is shifted to the defendants in the tort case to they're both presumed negligent. It's one injury. They're not going to split the injury up, but they are going to split the damages, and they're jointly liable because it was impossible to tell who hit the third hunter. Okay, so that's important to understand when you're going to get a tort fact pattern and it's not clear. There's multiple tort feasors. Now, they talk about independent intervening causes, superseding causes, and I'm going to get into that in a minute. So the Eggshell plaintiff case, Dulieu versus White and Sons, was where a pregnant woman was working in sort of like a restaurant bar type thing that her husband owned, and this is in the horse and buggy days, and she was washing dishes, and the defendant's servant had a horse with the coach and crashed into the bar. The woman was shocked and stunned. Her emotional state was such that she went into labor physically, gave birth to the baby prematurely, and the baby was having a disability the rest of its life because it was born too early. And so her husband sued, because back then women and children were property. And so this is where the Eggshell plaintiff comes in, and also re ipsa loquitur, about mental distress caused by the plaintiff, like IIED, intentional. Well, this wasn't intentional, it was more like reckless and negligent, but it was emotional. It was emotional damage. The emotional damage, to collect on that, you've got to be so serious that you're causing physical harm. And basically, the justice was Kennedy, and he noted that for lesser frights, fear, general distress does not cause bodily injury are not actionable in tort. So you can jump up and scare somebody, or you can do other things, but if it doesn't cause physical damage, they're not going to be able to. But at that time, the mother was indistinguishable from the baby. And basically, future cases, the courts might be ruling differently on mother and baby. But basically, it's a relevant case for causation. And, so basically, this is a article I pulled from the web by Geistfeld, and it's about proximate cause untangled. And I want to let you know that proximate cause, if you're in another jurisdiction, might be combined with actual and legal or proximate. In other words, this is another jurisdiction probably, because I'm reading off of it, and they relied on damages cases. The Eggshell plaintiff rule governs the determination of damages, so framing proximate cause by reference to this class of cases naturally produce the directness test. Now we're going to talk about the directness test and indirect, okay? So if you want to look at this and pause it and read it, you can. You can also go on Google Scholar and plug this in. It's a, how many pages is it? It was a 45-page article. Okay, so let's talk about causation. And I used Black's Law letter outlines. I also used some other cross-references. And so Black's Law letter explained about the jurisdictions, which I just discussed a minute ago. But if you don't, normally with causation for California purposes in the multi-state essay, you're not gonna have causation unless you have the two elements, factual cause. The first element's like the first test, and if you don't meet the first test, and you have that's the but-for test. The factual or actual is the but-for test. And if that doesn't get met, then try the substantial factor test. And then if that doesn't hit it, you can just say, okay, it's not causation. Then you move on to proximate cause. Okay, so basically, this is very important for when they're giving out the damages, and it depends on the state, okay? Because if you're comparative or, what's the other one? Anyway, so I'll get to that later. So I divided it the way that they have it usually: actual, factual, but for test. That's the first element of causation. And then the second is proximate or legal cause. So let's go over actual cause real quick. Okay, and then I'm going to give you an example that I found in one of the outlines. Okay, so actual cause is the but-for cause, the sine qua non element of causation. It is essential. Okay, and I just went over that real quick. Okay, so that's real simple. Now let's get to the proximate legal cause. This determines sort of like the scope of liability, and Bigbee versus Pacific Telephone and Telegraph was mentioned quite a bit, and this has multiple causes or indirect causes as part of the storyline, if you will, that go about defining foreseeability, directness, if the risk, if it's a direct cause and it was foreseeable, if it was indirect and there was an independent intervening cause. Now with this telephone case, let's just scroll down to the Bigbee case, because Ronald Reagan in the 80s did not want to pay high taxes. So he wanted to make it so the rich didn't pay high taxes, and also the companies that people had stock in did not pay high taxes, so the stock would go up. So he wanted to have this tort reform to lower taxes on corporations and big business and reduce their liability and responsibility, and he made fun of people that had damages. And there is this ongoing campaign against the little person's rights to recover when something's happened to him. Now, this case that Reagan kept having iterations of in a lot of his speeches, and it was the same as the hot coffee McDonald's case, where they used it to say that people are being litigious and that they really didn't hurt themselves and yada yada. But anyway, so the Bigbee case was this telephone booth. And they don't have telephone booths now. They stopped having telephone booths, I don't know when, probably in the 1990s. But when the cell phones came on the scene, they didn't have telephone booths, but they used to have these outdoor telephones that were like pay phones, and some of them had glass around them, some of them didn't. And they've pretty much dismantled them, and they're getting rid of wired phones. But people would walk around, they didn't have cell phones. You know, it was like, wow, you have a car phone? So I think it was in the 80s or 90s, you know, we were the first to get a car phone, and it was a big deal. And so this whole technology was such that they would put these pay phones outside so the phone company could get money, and they put it in a location near a highway and near a bar, and drunk drivers would come out and hit. They'd wind up hitting people that were in that location. It wasn't in a very good location, and it happened more than once. And so this guy's like partially crippled for the rest of his life. He was in the phone booth, I guess, and he was hit by a reckless driver. And you know, now in reality, he sued the driver. He tried to get insurance coverage, but he also sued. It was found that this telephone company kept putting the phone booth back up after other people were hit, and phone booth was smashed, I guess it made a lot of money. You know, people go in and have a drink, and then they want to come out and make a phone call from the bar. But but the location of it was so close to the highway. So the judge allowed it to go on and be decided, but it comes to it shows an example of direct and indirect causes and proximate cause and foreseeability. So it and that's what I just talked about a minute ago. So if you have an independent intervening event that's foreseeable, like a drunk driver outside of a pub with a phone booth placed right by the side of the road where there's multiple lanes of traffic, and where the speed is pretty high, and it's around a curve. You know, could they have moved the booth in and located it not around the corner or whatever? So basically, it was foreseeable that if it's near these bars or whatever, and near where the speed limit's higher and there's multiple lanes, that this could happen. And it would be foreseeable maybe if, you know, it's happened already. So basically, if the independent intervening cause is not foreseeable, uh, not like this case, but if it's not foreseeable, like if a tornado came through or something and it's an independent intervening cause and it did cause some of the damages, then you can terminate the liability of the defendant. And when you terminate the liability of the defendant, you wind up calling this a superseding cause. And I got this from Edward J. Kanoka, Torts Black Letter Outlines. You can probably cross-reference it somewhere else. Now, on the other hand, and Emerson goes on to do this crisscross thing about explaining it, but for me it clicked better because I always had a little trouble with this portion of torts, and now I totally understand it. But if it doesn't change the outcome, then the liability stands with the negligent party. Now, Emerson uses this electric pole, which is similar to this Bigbee case that Reagan kept bringing up. But I thought it was interesting to have the politics of how he put it. This is how Reagan put it. He said, in California, a man was using a public telephone booth to place a call. An alleged drunk driver careened down the street, lost control of her car, and crashed into the phone booth. Now it's no surprise that the injured man sued. But you might be startled to hear whom he sued: the telephone company and associated firms. That's right. According to Chief Justice Rose Bird of California Supreme Court, a jury could find that the companies responsible for the design, location, installation, and maintenance of the phone booth were liable. I suppose you all this might be amusing if such absurd results only took place occasionally. Yet today they've become all but commonplace. Okay, so this Bigbee case has been iterated or reiterated by others to say, oh, we need tort reform. And they did the same thing with the hot coffee, McDonald's. So they have a lot of propaganda and try to sway your opinion. But then when you hear the case and you understand why the courts ruled the way they did and hear the history, it might make more sense that maybe you ought to have a right to hold responsible somebody who was negligent. If a company is negligently placing something at a high risk in a comparative negligence state like California. Now, if you're in Virginia, that's another story because it's one of the handful of states that still has, gosh, I can't even say it. Oh my gosh. Okay, so we'll get into that in the next show. But there's different types of liability in tort. Okay, so there's how my hands hurting. Okay, so let's see. Let's see. It says, nevertheless, Reagan did not clarify that the decision only paved the way to a jury trial. The decision can go either way. Perhaps his aim with the Bigbee anecdote was to not place the blame for absurd results. So basically, he's insulting the courts, saying they're having absurd results on a runaway juries or litigious plaintiffs, but to attack Chief Justice Rose Bird. After all, in setting out loony outcomes in other jurisdictions, Reagan did not refer to any other judges by name, yet he neglected to mention the vote on Bigbee had been a clear majority of 6-1 in the California Supreme Court. So in the 80s, tort reformers, you can go look at that whole thing. So I'm going to leave it at that, and this is it in a nutshell. And there'll be more cases we can talk about, and we can finish up soon, hopefully. Thanks for listening. Take care. Have a great rest of your day. Bye.